Welcome to the NYU Forum. We are so excited today to have with us in conversation about her terrific new book, Lawless, How the Supreme Court Runs on Conservative Grievance, Fringe Theories, and Bad Vibes, the University of Michigan's Leah Litman. Leah is not a stranger to NYU Law, in large part because she hosts, along with me, Melissa Murray, a member of the NYU Law faculty, a podcast called Strict Scrutiny, which is about the Supreme Court. We also have another co-host, Kate Shaw, who is somewhere in the audience. Yeah, all we gotta do is start recording, and we have a full episode right here. But Leah, welcome. It's great to have you
so
here in the greatest city in the world.
They call it the Ann Arbor of the East Coast.
That's what I hear. That's what I hear. We don't have Zingerman, but we do have these terrific sandwiches and boxes. I'm going to give you a couple of minutes to maybe talk a little bit about the book, set it up for everyone, and tell us what this book is about and what drew you to write it.
Great. So first, thank you everyone so much for coming. I know there are a billion, trillion things going on at every moment right now, so I really appreciate you taking the time to come to this event and talk. So I'm just going to talk for a little bit, and I'm going to focus on parts of the title and parts of the subtitle of the book, which I think kind of capture some of the big themes. So first, why did I write this book? In a lot of ways, I think this book is the product of a long-running grievance that I have about the Supreme Court that really dates to my time clerking at the court. So I clerked at the court during the October term 2011 when they heard the initial constitutional challenge to the Affordable Care Act that almost demolished the entire law based on the so-called broccoli horrible. The idea that the real risk in the case was that one day the federal government would force us all to eat broccoli. I don't know, that sounds pretty good to me right now when I look around and see like what else the federal government is doing, but that's beside the point. And so to my mind, I saw this institution as really on the cusp or precipice of a disaster. And my initial instinct was to run away from it and to try to practice law in a way that was as far removed from the Supreme Court, constitutional law, and appellate law as I could. So I went to a firm and I said, how about those patent cases? And after a little bit, I eventually realized that the instinct that made me want to run away from the court actually made me want to educate people about the court, and that is part of why I returned to academia. And this book is really, I think, part of that effort. It is an attempt to try to socialize people in a different picture of the Supreme Court, to illustrate to them how the court interacts with politics, ideology, and society in a way that isn't so oversimplified that we just say law is all politics all the way down, but isn't so naive as we say the Supreme Court is doing something that is totally independent from and divorced from politics. So the book obviously is called Lawless. It comes from the bridge of one of my favorite Taylor Swift songs. And by this idea of lawless, I mean to capture a court that is running on things that we just don't associate with the idea of law, something that's objective or determinate, but rather a smattering of feelings, the zeitgeist of the party, their perceptions of reality that aren't rooted in fact, legitimizing political talking points, and how the effects of when they do that, when they run on things that aren't really based in law, are to make the country less democratic, more lawless, and undermining the rule of law. So that is the high level kind of capture of the title. And I'm happy to talk more about what I mean by bad vibes or conservative grievance, just to take an example of a bad vibe that I think is something that we are living with the consequences now. When the Supreme Court really started cannibalizing modern campaign finance regulation in Citizens United versus FEC, one of their rationales for doing so was that these huge, massive amounts of spending, this unlimited money that could be poured into elections, one, did not give rise to corruption, And 2, did not even give rise to the appearance of corruption. That is a vibe. That is not a fact. That does not describe most people's perceptions of reality. That does not describe how we see our elections working. And yet, that very consequential, I don't know, slapdash phrase or intuition that they just wrote into an opinion, again, we are living with the consequences of that and have been for the better part of a decade. Just to give you an example of conservative grievance, also drawn from the area of campaign finance regulation, turns out that part of the reason they have been cannibalizing campaign finance laws that restrict the amount of money that people can spend on particular candidates or give to particular organizations is this idea that actually campaign finance regulation victimizes the mega rich, because it takes away from them something they are entitled to do. Use their money to get even more power, to select who will govern us. And it's this ability to invert the idea of equality, discrimination, power, powerless, that I think also captures some of the lawlessness of the modern court.
Okay, so that's a thumbnail sketch of the book. If your appetite is whetted, you obviously can purchase the book, but we also will be having a drawing for 10 signed copies of the book. So right now, there are index cards being circulated. Shirley here has an index card. If you wish to be entered in the drawing, please write your name on the index card. At the end, we will do a drawing, like literally an old-fashioned drawing where I will select 10 names and 10 people will win the book. We ask that there's only one index card per entrant, so stop the steal. Okay. All right. Yes, please raise your hand if everybody wants a card. Amazing.
You get a card, you get a card.
All right, so let's dive in deep. That was a great way to sort of set things up. I want to talk a little bit about the recent landscape of the court. Let's call it a landscape. The court has been doing a lot. And a lot of this has been done largely on what is known as the shadow / emergency / Trump / interim. I think we should just call it the docket formerly known as the shadow docket, like Prince or Madonna, and just go from there. So there's been a lot of stuff going on the shadow docket. Most recently, a ruling from the court without much explanation that allows ICE enforcement to essentially racially profile in some of the largest cities in the country. So is this part of the conservative grievance? Like, how might we actually criticize the court about this decision when we don't really know what they think?
Yeah, so shadow docket has been shadow docketing all summer long and even before then. And I think that the court's increased heavy reliance on the shadow docket is emblematic of one of the ways I would describe the court as lawless. We think of courts and judges as different from other institutions, in part because they give reasons for their decisions, and then they follow those reasons, those principles in other cases, even when they might not like the results. That is just not happening on the shadow docket. Like, we don't know why they undid the ruling from the district court in California that had restricted some of ICE's more abusive exercises of immigration law enforcement authority. I think one possibility is a kind of subcategory of how the court enables lawlessness, and that's by removing any consequences from public officials who violate the law. Like, I think of this in my mind as like a law for lawlessness. One reason why Justice Kavanaugh suggested the district court's limitation of ICE practices was improper is because the plaintiffs in the case didn't have what's called standing. They had not established that it was sufficiently likely that they would be injured in that they would be swept up by one of these immigration raids. And it is limiting people's ability to challenge and limit unlawful government practices.
So let's step back. So the court issues this decision. A judge in California enjoins ICE enforcement from making detention stops that are based on the race of the individual, whether the individual speaks Spanish or speaks accented English, or whether the individual is in a place that is likely to be a place that is frequented by those who are undocumented. And so like typically some of the places where day laborers might congregate. That is enjoined. It is appealed. The Ninth Circuit leaves the injunction in place. The administration appeals the Ninth Circuit's actions to the Supreme Court, which stays the injunction, meaning the injunction is no longer in force and ICE can continue to do these things. And there's no word from the Supreme Court. The only thing we have to go on that gives us a clue about what the court is thinking is the fact that Justice Kavanaugh, in his beneficence, wrote a concurrence, a cavcurrence, if you will. And we get a sense from his concurrence that at least one of the things they are fighting over is this question of whether the challengers, who are American citizens or immigrants with documented legal status, but who were detained, actually have standing to bring the case, because although they had been detained previously, they cannot show with any specificity that they are going to be detained in the future. And this is an issue that comes up in a very famous constitutional law case called Lyons versus City of Los Angeles that for years I've been teaching, and for years it has been vexing my constitutional law students because it seems so imminently unfair, right? How are you going to get justice if you can't show that the unjust thing is actually going to happen to you, but it seems like it's pretty likely that the unjust thing is going to happen to you. So can you explain a little bit about Justice Kavanaugh's rationalization? I mean, he basically talks about like, it's not a big deal to be detained.
There's so much going on in this Justice Kavanaugh concurrence. We could probably spend the entirety of this forum talking about it, because in addition to suggesting that the plaintiffs didn't actually have a sufficiently high level of fear that they would be swept up in one of these, arrest first, question and prove your citizenship later schemes, is this idea that in his view, what ICE was allegedly doing was just common sense. Like, to him, the idea that immigration enforcement officers could question people on the basis of their skin color, whether they spoke with an accent, whether they were hanging out at Home Depot. He described that as not only consistent with the court's precedents, but common sense. And I think this is, a revealing instance where the justices' decisions, even their reasoning, are just straight up their own perceptions and rough cut assessment of what's fair, what's just, and what makes sense or common sense in this case. Justice Kavanaugh also, as you noted, basically attempted to reassure everybody that there wasn't anything to be concerned about in these stops because all ICE was doing was questioning people and then promptly allowing them to leave once they indicated they were citizens or were here lawfully. We live in a modern society where there are iPhones and there are cameras. Like, we all know that's not what's happening. And yet his insistence to the contrary is just this example of how they inhabit this alternate reality and fashion the law based on that. So those are, three ways that the Kavanaugh concurrence alone underscores the extent to which the court is fashioning a body of law that enables lawlessness because it undercuts all of our ability to hold the government to the law. It also, is just lawless because it's just based off of what Brett Kavanaugh thinks makes sense and what he thinks is going on, even when there's an awful lot of evidence to the contrary.
So when did this all start? I mean, can you pinpoint a time when the court stops doing law and starts doing, as you put it, vibes?
Yeah, so I can point you to what I consider a moment where the court went off the deep end and then realized they wouldn't actually face any consequences for doing so. And that's Bush versus Gore. The idea that the Supreme Court would intervene in a presidential election, halt an effort to actually count the votes and determine who would be president, invent a legal theory in the case and describe it as good for that case only. And then the rest of the country would basically say, okay, that seems bad, but we're good with it anyways. One of the remarkable things to my mind is some of the retrospectives on Bush versus Gore. So in Justice Breyer's recent book, or I think his second most recent book, he talks about the fact that the public accepted the result in Bush versus Gore as a good thing, as evidence that the court's institutional authority has been so preserved and so cemented that that is what makes us a government of law. And to my mind, Bush versus Gore is not an example of a government that is bound by law. It is an example of a court that, Justice O'Connor was at a watch party when she saw Al Gore, vice president, go ahead. She reportedly said, that's terrible, because she wanted to retire. So we know some of their motivations. We know, again, the consequences of that ruling. So I think that is one example where, again, they went utterly lawless. Nothing really happened to them as a result. Some of the justices had some tough questions lobbied at them when they actually deigned to appear before Congress, which used to be a thing the justices would do. And from there, they basically divined, maybe we can get away with even more. And I think that is also, unfortunately, the lesson they have internalized from Dobbs overruling Roe. There was this brief moment, the 2022 midterms, where it seemed like the country was willing to push back against what the court had done and vote against the party that had appointed the justices who would overrule Roe. Then what happens in the first presidential election after they overrule Roe? It is a sweeping victory for the Republican Party. And I think some of the acceleration we are seeing on the shadow docket, some of their willingness to give the Trump administration an unbroken streak of 18 victories on the shadow docket, comes from a place of not only #YOLO, right? Like, let's just do it while we can, but also, like, nothing's gonna happen to us if we do.
So there are a bunch of different actors here, and we shouldn't focus solely on the court, but think about the court in concert with all of them. So we have an executive that is being increasingly assertive about a particular vision of executive authority. We have a Congress that has been relatively supine in pushing back, certainly on the executive's encroachments on its own prerogatives. And then we have the courts, and not just the court, but all of the courts. And there's an interesting friction that's going on amongst all of the branches and also within the various branches. So there's definitely some friction between the courts and the executive. Congress seems to be on the couch, not really beefing with anyone just yet. But within the court system, there's a lot of friction between the lower federal courts and the Supreme Court. And that's actually, I think, really unusual. We haven't seen that. Last week, or maybe it's 2 weeks ago, Lawrence Hurley of NBC News reported on a series of actually stunning interviews with about 12 judges from both sides of the ideological spectrum, all of whom were kind of angry at the court for, one, not providing any explanations for their shadow docket decisions, and two, issuing decisions that made it look, because there was no explanation, like the lower courts had kind of been willful in getting it wrong, right? Is this unusual, and how has the Supreme Court cultivated an environment where this kind of inter and intra-branch friction is now commonplace?
Federal courts, I am your anger translator if you want to read something about the Supreme Court.
A lot of these folks are 1Ls. They haven't had the joy of federal courts yet. They are having the joy.
I was just speaking to the federal judges.
Well, they're experiencing the joy of civil procedure, which is like federal courts light, but not really.
You should all take federal courts. So the fact that federal judges were actually willing to speak to a reporter on background and allow the reporter to report on their concerns and dissatisfaction with the Supreme Court is just a remarkable, stunning development. And I think it speaks to the extent to which there are real concerns with serious institutionalists and people who are well familiar with the work of the courts and how courts should be working with what the Supreme Court is doing. In addition to the aspects of the Supreme Court's decision-making process that are giving lower federal courts pause, including that they are issuing these decisions without explanation or reasoning, that they are signaling that the lower federal courts are doing something untoward. I think that this is also an instance where what is happening in the executive branch is really important, because the Supreme Court is issuing all of these unexplained, unreasoned decisions, suggesting the lower federal courts have gone off course, and so off course that their decisions warrant emergency, extraordinary, discretionary relief at a time when the executive branch is engaged in this full-on assault with the very concept and existence of judicial review of executive actions. We've all probably heard or seen the quote from the now vice president before he was the vice president, invoking the historically inaccurate claim that President Andrew Jackson said of the Supreme Court, he's made his decision, let him enforce it. They have repeatedly described lower federal court decisions that go against the administration as illegal, unconstitutional, unfair, reflections of partisan warfare. We're seeing a huge uptick in threats against federal judges. And the fact that the Supreme Court still manages to conceive of itself as more aligned with an administration that is actively attacking the lower federal courts rather than aligned with the people who are part of the same institution as they are, I think is just another indicia of how far the court has gone in just becoming aligned with the ideology and the preferences of the Republican Party.
Well, let me push back. Are they aligned with the administration, or is it they're aligned with a particular ideological vision of the Constitution? And I know you're thinking specifically of Justice Gorsuch's comments about Judge Young's decision. Yeah. Judge Young is a judge on the District of Massachusetts who was chided by Justice Gorsuch in a concurring opinion in which Justice Kavanaugh joined for failing to follow an earlier shadow docket decision that literally was, I think, maybe a few sentences. And Judge Young in open court said, my bad, my dudes, like, I didn't know what you meant. Like, it was 4 sentences. I genuinely, I'm 80 years old and I've always followed the court and I just didn't know what you meant. Are they aligning themselves with this administration, which is, again, like a political kind of move? Or are they aligning themselves with a particular jurisprudential ideology, which might be more in keeping with the sort of law-politics divide?
Yeah, so I think that in these cases, the jurisprudential methods that they have attached themselves to are so deeply interconnected with and steeped in the ideology and politics of the administration that they're not perfectly separable. So just to take one, for example, this idea of the major questions doctrine, this is the judicially invented rule that Congress, when it empowers administrative agencies, doesn't actually allow administrative agencies to create big, significant regulations. And what administrative actions has the court invalidated under that doctrine, ranging from the Clean Power Plan to student debt relief to other initiatives of Democratic administrations. And yet, what hasn't given the court pause is the Trump administration's single-handed demolishment of the Department of Education, which last time I checked, there's no statute authorizing the president or the Secretary of Education to dismantle a department that is created by Congress. So I think the underlying ideology of the major questions doctrine reflects the deregulatory instincts, the receptivity to corporate interests and corporate power that are also very much a part of the politics and ideology of the administration. Do I think that what the Republican justices are doing is because they love Donald Trump and he's a Republican? No, it's because I think their worldview shares, unfortunately, much in common with the worldview of people in this administration. Their ideologies overlap, and that allows them, and they have done this, fashioned law based on that ideology and worldview. I mean, even when you think of originalism, one of the parallels I try to show in the book is that originalism, I mean, it kind of parallels in important respects the entire idea of make America great again, that we should return to some righteous past to restore things the way they were. And so I think there are various parallels in the substantive elements of the court's jurisprudence, their methods of interpretation, and the ideology of this administration that you can see sometimes in how they justify the methods of interpretation or in how they apply them.
Let's talk a little bit about originalism. Again, there are a number of 1Ls here. What's a working definition that you would use for originalism?
Originalism is a they, not an it, because it turns out originalism has become this endless cycle of theories that anytime there is a challenge to originalism, a new version of originalism comes out, adapts to that challenge. So it's almost like originalism itself is like a living constitutional method of interpretation.
Or influenza.
Right, or influenza, yeah, different strains. Yeah, I don't know if we're at Alpha, Omicron, or Delta at this point. But originalism, as a general idea, refers to the notion that the Constitution means today what it meant when it was ratified, unless and until it has been formally changed.
Through the amendment process.
Through the amendment process. And I can tick through the different varieties of originalism, some of which focus on the intentions of the people who drafted or ratified the document, some of which focus on the ratifier's understanding of the words and the semantic, like legal meaning of those words, some of which focus on how people at the time would have resolved legal questions about the Constitution's meaning. Those are just 3 varieties. I haven't even gotten to original contours originalism, which is something Justice Barrett just threw out in a recent Second Amendment case. So it's a family of interpretive theories.
I think we called that the cool sculpting of originalism, the originalism contouring.
Who knows? But it's this family of interpretive theories that is designed to point us to some prior moment in time when the meaning of these provisions was fixed.
Well, and so the animating principle or impulse behind originalism is this idea that without some restraining force like history, judges would just do their own things. They would let their freak flags fly and they would impose their own prerogatives on us all. And the virtues of originalism is that it requires the judges to be shackled to history, tradition. And it sort of presents this idea that history and tradition is completely objective. But I think we see in a number of the decisions that, 1, these are not trained historians, right? So there's that. 2, history itself and the doing of history is actually an active and agentic process, not necessarily entirely objective. Like historians cull and curate and then interpret what they see. And so the idea that it's this entirely objective may be a fallacy, but it is the fallacy on which this method is rooted. There are also, I think, objections you can make to originalism about looking to history when there's something anti-democratic about those historical moments that you are privileging and then applying their lessons to the current moment. So how does this court do originalism? Is it a kind of faithful originalism, or is there a number of different strains that are being done, and who's doing them?
So I have at times referred to what the court is doing as originalist hotboxing. Like they just put themselves in a room, put up a bunch of historical materials and ask kind of what moves them based on that. So I think there are some cases where the history that they offer looks just kind of like bad law office history. But then there are times when they just don't purport to do originalism at all. So in 2013, when the court invalidated the preclearance process that was part of the Voting Rights Act in Shelby County versus Holder, there is no so much as a mention of what the Reconstruction amendments, the 13th, 14th, and 15th amendments did by way of altering the balance of power within our constitutional system or allowing Congress to tackle the challenges that we're going to be confronted in trying to transform the country into a multiracial democracy. So it is selective originalism all the way down. It is selective at the moment of deciding whether to do originalist at all. It is selective in the process of culling which history matters and which history doesn't. This is a point Justice Jackson raised in the context of the Second Amendment, where some judges, some colleagues say, well, we can't look to those parts of history because they are too enmeshed with legacies of racial discrimination or religious discrimination, so we're just going to pick out these other ones. And other times it's just selective in that there's so much conflicting evidence and it can't possibly lead to a clean outcome in the way the justices are insisting, and yet they insist it does anyways.
Well, here's a good example, I think, of that impulse. The court has, over the course of several decades, really whittled down Congress's enforcement power under the 14th Amendment. And then we saw in 2024 in Trump versus Anderson, when faced with a question of first impression, whether or not Section 3 of the 14th Amendment, which bars those who have participated in insurrections against the federal government from holding office going forward, whether that would apply to a presidential candidate, the court insisted that it was doing originalism, and the original meaning of Section 3 required Congress to first enact legislation that would give Section 3 meaning. And one could ask, if that was required for Section 3, it would also seem to authorize Congress to do things vis-a-vis the other sections of the 14th Amendment. So how are they doing this so inconsistently and literally no one is calling them on it?
I mean, I feel like some people have tried to call them on it, and for whatever reason, it hasn't hit, like it just hasn't stuck. You and I were recently part of a conversation. This will ring a bell, I promise.
We're part of a lot of conversations
it
together.
Is true. Okay. I'm going to try to be somewhat general about this, but you were posing the question of what can be done in this moment to address some of the challenges our country is facing. And let's just say someone who was in a position to do something answered, let's file some cases. The courts, the Supreme Court, right, they're going to get us out of this. And I thought, what planet are you living on?
Okay, I do remember now.
Okay, so I don't know why it hasn't stuck, because people have been trying to make these claims about the failures of originalism, the inconsistencies of originalism. Part of why I wanted to write this book is to try to reach other people and convince more people that the court is part of the problem, and that in any kind of broad systemic solution to the failures of our democracy, we need to also be thinking about the Supreme Court. So I don't know exactly why it hasn't registered or stuck. I think some of it is failure of...
Well, isn't there kind of Warren Court hangover
That's
happening?
where I was going to go.
Okay.
Yeah, so Warren Court hangover. Warren Court, of course...
This is a real term.
Yes.
That we made up.
Warren Court, not Warren Court hangover, but Warren Court refers to the court when it was led by Chief Justice Earl Warren. It is by far and away the most progressive court in United States history.
Spoiler, it wasn't that progressive though.
No, this is all relative.
Yes,
right?
the bar was here.
Yes,
Okay.
if you're comparing yourself to like Roger Taney, then you're gonna look pretty progressive.
Roger Taney is the Chief Justice who authored Dred Scott. So again, the bar was here.
Yeah.
Okay.
But I think the country too often associates the Supreme Court with the Warren Court, when the reality is throughout history, that is not how the Supreme Court has operated. The Warren Court lasted much less time than the Roberts Court has. And yet when we go to school, elementary school, junior high school, we learn a story about the Supreme Court that kind of runs like, well, first there was Dred Scott versus Sanford, and then the Supreme Court upheld separate but equal segregation in Plessy, but then the Supreme Court saved us all in Brown. And that's the end of the story. So the punchline is the court fixed it. Whoa, right? Like, let's talk about what happened after that, because ever since then, right? Well, so let's talk about what happened after that, by far as like what the Roberts Court has done with efforts toward immigration.
I was thinking about the Warren Court like not being super clear about what integration would require. And how it would be
let's
done.
talk about how the court didn't actually bring about integration, because they weren't the ones actually enforcing guarantees of non-discrimination. It took Congress. Right, to enact civil rights statutes. It took a president and agencies to implement those statutes, and that picture isn't part of general public education. I think also some of the story is we all want heroes, like we all want someone to come and save us. And it would be really nice if there was someone who was just gonna come and fix this. And there isn't.
It's not Sam Alito.
It's definitely not Sam Alito.
Okay. All right, let's shift back again. You've painted a really important picture. I mean, maybe you have another book. Maybe there's a sequel. Here's an idea for a title: Lawful. Like, get it? Law awful.
Yes.
Okay, yeah. But there's something here about the interplay between the branches, or what happens when there is a failure within a branch. I mean, you just mentioned Congress stepping up with the Civil Rights Act of 1964 to essentially give contours and meaning and a method for enforcing civil rights that the court could not provide. Like, the court could decide Brown, but it couldn't make the South desegregate. It required Eisenhower sending in the National Guard to do that. There's a story here about the court and the other branches. What in this moment could Congress be doing to corral the court, maybe to impose some more order, to require the court to explain itself? I mean, or is the court kind of off on its own island, essentially doing what it wants?
So I think right now they are off on their own island, doing what they want. So much so that Samuel Alito felt comfortable giving an interview to the Wall Street Journal in which he declared that Congress basically has no power to regulate the Supreme Court and their jurisdiction at all. Never mind, there is literally a clause in the Constitution that says the Supreme Court has jurisdiction except for regulations that Congress may provide, details. But what could Congress do? I mean, any number of things. I think there are the category of things that people put in the bucket of Supreme Court reform, such as, for example, creating an actual enforceable ethics code, changing the size of the Supreme Court, altering the Supreme Court's jurisdiction, creating term limits for justices. Those are all part of it. And then I think there are the softer powers. I referred to how Supreme Court justices used to actually appear before Congress. Congress could do more to try to get them to do that again.
To be fair, Congress did ask the Chief Justice to come talk about the ethics violations.
He said, "Thank you, next." Boy, bye. Yeah, no, that was not happening. But the Congress controls their funding.
Yeah.
Why allow these guys to have law clerks if they're not even going to write opinions?
But couldn't this go the other way, though? I mean, so right now we have a Congress that has been relatively reticent about checking this president. What if the Supreme Court were to do something to hold the administration accountable, and then Congress brought them in and said, you know what, we're turning the lights off at 1 First Street?
Yeah, so
Is this a slippery slope?
So it's a slippery slope in the sense of when you enhance political control over the Supreme Court, there's going to be more political control over the Supreme Court. I think decisions about allocations of institutional responsibility, like which institution should have what, should always be sensitive to what those institutions are actually doing, as well as some historical context. And I think because we have overemphasized the Warren Court period, we are so fixated on the possibility that the Supreme Court is going to do a good thing and the political process is going to do a bad thing, that we have just entirely excused the opposite situation, where the Supreme Court is doing doing a bunch of bad things, and Congress, we are wary about having Congress to exercise any control whatsoever.
Is this just because we think our whole government is bad all the way down?
I don't know.
It's not a flip question. I mean,
No.
Gallup polling has shown that Americans' faith in government institutions has been steadily eroding over years. Are we just at the point where people don't believe the court is legitimate and haven't really felt that politicians and the institutions that they inhabit are legitimate?
Well, I think we are at a moment where all of our institutions are in need of serious reform. When I mentioned earlier that I think the court should be part of conversations of democracy reform, they shouldn't be the only part of that. Obviously there are serious issues with gerrymandering in Congress, voter suppression, Senate malapportionment, the Electoral College, and we could go on and on, how the filibuster is adding additional, minority rule within Congress. So I think that all of our institutions could be improved. We could do things that make it less likely that a minority rule party that is interested in autocratic authoritarian power would regain control. And I think there would be things that could be done about all of our major institutions that would reduce the odds of that happening in the future. But I don't think the mere prospect that Congress would do something in response to a Supreme Court decision makes the calculus such that we should just reject that possibility and hope that the people that we are putting on this institution for life right now, who aren't subject to re-election, will just do the right thing, because I just don't think that has played out. And I certainly don't think that's how it's operating now.
Let's shift to a different topic before we turn to audience questions. We have about 10 more minutes. Let's not talk about the justices as justices. Let's talk about them as authors, right? So a lot of justices writing books. One, why so wordy?
Those dollar bills.
Okay. So that's actually—
I did not get a $2 million book advance, like some Supreme Court justices.
And again, this is across the board. Justice Sotomayor has written a number of books, both her autobiography and children's books. Justice Jackson had her autobiography, lovely one, out last year. Justice Gorsuch had, A Republic If You Can Keep It.
Sam Alito has a book coming out next year.
Does he? Oh, that's right.
Oh, yeah.
Justice Alito will have a book coming out. So one, what do you think what's going on that there's so much appetite for Supreme Court books? I mean, are people just really now deeply interested in how the court works and hoping against hope that the justices will really spill tea in the books? Like, spoiler alert, they're not going to spill any tea, right? Right, there's no tea in the books. But why is there so much appetite around them? But that's the first question, there's more.
So probably a combination of reasons. I mean, one, the Supreme Court is very powerful. Its decisions affect all of our lives. So I think it's natural for people to want to know more about the people who are making those decisions. I think also the justices have fans. Some of this is just fan service. And no, really. And,
you could just make bracelets.
You could. I mean, there were tote bags and whatnot for Justice Ginsburg, not a positive development. And yet, right, this seems to be part of our attitude.
So is she sort of the fulcrum?
Yes.
Like, you think Justice Ginsburg is where the switch happens and the justices become much more public-minded?
Not necessarily the fulcrum. I think there are certain features of what we are seeing now that are also traceable to Justice Scalia, because Justice Scalia conceived of himself as someone who was speaking to an audience that wasn't primarily his colleagues. He talked about how he wrote dissents for law students, for future generations of lawyers. And so I think this effort to reach the public, this effort to speak to the public, to galvanize them, to defend what you are doing, comes from previous justices. It just so happens that Justice Ginsburg had a very cool nickname and meme associated with her.
That was born right
RBG.
here at NYU Law, yes.
Yep.
An NYU law student came up with that. It's a great point. And they're not just writing these books. I think they're also speaking to the public in their opinions. Like you've mentioned before, Justice Jackson has really been engaging in what might be called demos prudence in her dissents, certainly to many of the shadow docket decisions where she's using a kind of colloquial vernacular that, for some, pushes the envelope of what they expect from a Supreme Court justice. Like, what about those norms? I mean, is something being violated when we hear the justices and they're a little too much like us?
Yeah, so I think this is a kind of context-dependent inquiry. One, I don't think justices or judges should be in the habit of kind of taking, I don't know, rips at litigants and mocking their arguments. You know, I think sometimes some of the justices' efforts to be clever or funny or reach audiences probably veer in that direction. On the other hand, I think it is a deep failure for anyone who is in a position of authority and anyone who is in a position to speak to the public to act like what the Supreme Court is doing and their decisions are just totally normal and affording them a presumption of
regularity,
of normalcy, of legitimacy. And so I think the most available avenue is to write in dissents, right, and try to say what is happening with this institution isn't normal, you should be concerned. They can also do that in public speeches. And it's a balancing act, again, between not mocking, individuals who are less powerful, not taking pot shots, but I think failing to respond, to acknowledge what is happening is at least, if not worse, a failure.
All right, so I'm going to turn to the audience now for questions. A couple of students actually submitted questions in advance, and they're, as is typical of NYU law students, profound. So I am going to read them. So the first is, how do these seemingly subjective and extra-legal emotions and perceptions influence judicial decision-making? By acting on these feelings, is the court undermining the very idea of law as an objective, dispassionate system?
Yeah, I think the court is undermining the very idea of law as an objective, dispassionate system. I can give examples. I think one of the clearest instances is the major questions doctrine, which we were talking about earlier, when the court wrote the opinion invalidating the student debt relief plan. Chief Justice Roberts literally cited an opinion piece that described student debt relief as a personal and emotionally charged issue. And that was the basis for them not applying their usual rules of statutory interpretation, textualism. So yes, injecting your feelings into the law, right, declaring your feelings to be the law is undermining the project of law itself. Like, I am not someone who is full-blown legal realist, like there is no difference, but.
Okay, here's another one. Your book is grim.
Thanks. Grim with a dose of laughter?
Your book is grim. What is a young and once optimistic law student to do? I'm in my first year. What are some things that me and my classmates can do to make all of this better?
That is a wonderful question. No, it is a wonderful question because it reflects an understanding that so many people don't have, which is no one is coming to save us, right? Like, we have to do it ourselves. So what can you do? There are so many different things lawyers and law students can do. One is, even at a moment where we're seeing the Supreme Court, undo so many rulings of the lower courts, like, there is still no doubt in my mind that litigation against illegal executive branch practices is worthwhile. Not all of these rulings are going to be undone. Some of the harm will be avoided. Not all of the rulings, are going to be appealed, and some of it is just going to be slowed down. So if you want to litigate, like, there is still room to litigate and do good things. I think lawyers also have an obligation to the public to uphold the rule of law, and that includes educating people about what is happening. I think a lot of people check out about coverage of the Supreme Court and law because they assume it's too complicated. You should never relinquish, right, power over something that is as consequential to your life as law, courts, and democracy. And so I think to the extent lawyers can use, right, what you are learning in law school to educate other people, whether that is through community meetings, whether that is through organization, whether that is through get out the vote efforts, you name it. I think this is also a very useful skill. And be creative. take risks, thinks about like what options aren't on the table that you think would improve our democracy, and try to go for them.
Just a tip or a plug, there are 2 public elementary schools within walking distance of NYU Law, and most public schools do not have funding for basic civics education, so the kids, as part of the social studies curriculum, don't ever learn about the Constitution and the branches unless someone affirmatively goes there, and I did for a very long time go there when my kids were students at the schools. But that is something that law students could also do. All right, one last pre-submitted question, but I want to get questions from all of you. So if you have a question, you can start forming a line here, some microphones, you can come up here to ask your questions. But here's the last question. This is from an LLM student. Justice Kagan has been accused of appeasing her conservative colleagues. I think I accused her of that. Justice Jackson has written multiple scorching dissents, often not joined by the other Democratic appointees. Justice Sotomayor has sometimes been described as falling between the two. Do you think any of these approaches is more beneficial given the current court? What advice do you have for getting the ideas and concerns expressed by these three justices into the hands and hearts of the public who might be disconnected from the work of the court?
Yeah, I think it is a difficult calculus for them to make about what option is better, in the aggregate. I think to the extent you think holding back is helping with harm prevention, right, is avoiding some outcomes that you genuinely think would have gone the other way had you not held your tongue, right, had you not kind of sat down. I understand the instinct to do that. I tend to fall more, on the spectrum toward Justice Jackson, which is this court is just doing so many wild things, and you need to inform people about that, because the ultimate solution isn't going to be convincing your colleagues, just kind of like calm down, slow down, right, and do the right thing. It's going to be convincing the public to actually engage in the kind of politics that would be sufficient to change an institution like the court.
I believe the Justice Jackson approach you've termed dracarys. Right.
Yeah.
It's a Game of Thrones reference, Kate.
Yeah.
Okay. All right. All right, questions from the audience. We have 2 microphones here. You're just speechless. No. Oh, I can also cold call you. Okay.
I can also talk about the cardigan that Taylor Swift just released to promote Life of a Showgirl. Yeah, no, get online.
Let's not talk
right,
about
it's
that.
going to be sold out very quickly.
Yes.
I bring a viewpoint from the old people.
I am one of you. Hello, welcome.
You've characterized a lot of the misdeeds that are going on, but I don't think you've characterized it as badly as it sits. We have a Supreme Court that is simply dedicated to justifying their ends with any means possible. There's no intellectual honesty there. And the Dobbs decision, and I don't mean when the justices said that they would vote to uphold Roe. I mean their reasoning for getting rid of Roe is simply intellectually dishonest. They recognize implied rights with the right to self-defense. They don't recognize implied rights with the right to an abortion. So we're not adequately characterizing how bad it really is. When I was in law school in 1965, Justice Harlan and Justice Frankfurter were the major conservatives, and white as well. If you read their opinions, they are along a reasonable spectrum of left to right. They are consistent, and they have a jurisprudential founding. The Supreme Court now has no jurisprudential foundation. It's made up as they go along. The major issues doctrine has some history to it, but the way it's been used recently is simply made up as they go along to achieve an end. That needs to be more loudly characterized and denounced. And the other aspect that—
Is there a question? I'm just asking.
Yeah.
Okay.
Do you urge the students to go to this greater, more radical definition? And the part of it also is good faith. What they're doing lacks good faith because it's political jurisprudence, it's not good faith.
So how do we as professors counter what is, I think, a faithless kind of jurisprudence in how we structure our classes and teach our students at a time that is really politically charged, where any form of dissent, I think, could be reasonable, could be a problem.
Yes. So what I tell my students in constitutional law is I am not here to teach you a set of doctrines, right? If you think I'm just going to teach you the rules and at the end of the semester that's what you're responsible for, like you are missing something, those rules probably aren't going to be good at the end of the semester, much less by the time you graduate or take the bar anyways.
Can confirm.
Right, exactly. So like what I am trying to teach you is how the court has shaped the law, how law changes, how the court interacts with law, politics, and society. You know, in all of the readings, I'm not just giving judicial decisions. I give, here's what the executive branch is doing, right? Here is some social movement history that explains, the organizing efforts that were behind, the production of materials that the justices relied on. I'm not here to share like my views on this, but I want to give you much more information about how the court operates so that you are in a position to form your own opinion, right? Including an opinion that, the justices aren't acting in good faith. And that they are just trying to rationalize the outcomes that they instinctually pull to. But it's not my job, again, to either teach you here's a set of rules that you just need to memorize, or here's my view of the Supreme Court.
It is actually really interesting. I think there's so much discussion, certainly on the right, that law professors and professors more generally are indoctrinating students to be skeptical of these institutions, and I find they're skeptical when they come.
Yeah, exactly.
And I'm just no, really, there's doctrine here, and they're like, is there? And I mean,
what is doctrine? It's not real.
I mean, it is actually really, and it's a great point that the median justice today is really different from what it looked like before, and the conservative justice today is very different from what it looked like before. Okay, yes.
Thank you so much for the conversation. You mentioned earlier that the Supreme Court is at an all-time low in terms of popularity and trust in the institution. So I'm wondering, in your opinion, why aren't more elected officials or people who are running for office running on the court? We've seen Sheldon Whitehouse and Bernie Sanders sometimes, but why are there not more people in leadership talking about this and making it an issue?
I don't even know how to begin to answer that question, because this is something that is also extremely enraging to me. I think you can run against the court because the court is functioning kind of as an opposition party, in a lot of important respects. The court is doing things that are deeply unpopular. As the previous question suggested, they are representing an increasingly narrow segment of the country. Why aren't they doing it? I can only speculate. One is they were socialized during an era of the Warren Court, and they just refused to update any of their priors. Second is, they just gravitate toward institutionalism. And so instead of asking, how is this institution functioning? It's an instinct just to defend institutions all the way down. Third is, they're concerned about the Brown situation, about politics being used against a progressive court, again, even though that has been the exception. So those are three possible reasons. Fourth might just be a lack of familiarity, and they're just more comfortable kind of talking on their own terrain. I don't know why they aren't doing this. I wish they would.
Can I add a corollary? This is based on a conversation that Kate and I had with some folks in the administration. I think they genuinely don't think the public is interested in the court or can follow the thread of what the court is doing. And so, I mean, maybe it is just low expectations of the voters, but I think they think it's too complicated. And I think that's why we are we're here to help. But I think they think that there's a big gap to traverse in trying to make the court relevant to the average voter.
And that's just such a failure, because part of politics is making an issue,
Yes,
right?
that part.
You are in a position to educate people. You are
Yeah.
in a position to show them, right? It's not just to take public opinion and do that.
All right, so we have two more questions, and I also have a hat with a bunch of different names I'm going to pull out. So can I take your two questions together and we'll maybe synthesize them?
Yeah, plenty of time for the questions and then the hat.
Okay, time for questions and a hat. Why don't you?
Hi, I'm actually not a law student. I'm doing undergrad at NYU. I came because I really like the podcast.
Always fine.
I like the podcast too. I chose to be identified on the cover as co-host of the podcast Strict Scrutiny rather than law professor or Supreme Court clerk. So also a fan. Sorry.
So I started reading Lawless, and I was really shocked by how easy it was to understand, because even when I listen to Strict Scrutiny, sometimes I have to listen a couple of times to fully get
That's
it.
Kate.
And I do think law is and Constitution is very complicated, and I was just wondering, what are some ways we can, kind of following up on the previous question, we can make people care about it, because I do think it is such a big part of everything that's happening around us. And I wanted to say, it's really cool that the book cover matches with Taylor Swift's 12th album, and your blazer is also matching.
I try. So question is kind of like, what can the public do, right, in order to get people to understand and feel comfortable engaging with, Constitution, courts, and the law? I pick up the previous suggestion, go into public schools, right, be part of civic education. Talk about the court. I annoy my swim team endlessly by bringing up the court whenever they bring up something. My response is, let me tell you about how the Supreme Court affects that. So it's, everyday conversations. It is public education, and public education means different things. It can mean showing up to endorsement meetings. It can mean showing up, right, doing kind of get out the vote efforts. It can mean a million different things, but we have to have these conversations, and you should be comfortable talking to people about the court, because you know enough, right, to communicate to people like what is happening.
Call your congressman or
Yes.
congressperson and tell them, like, I want to know what you think about the court. What are you going to do about the court?
All right, thank you so much, thank you.
Thank you for listening.
Yes.
Okay. Are you a listener? No, you don't have to be. Like,
A couple of episodes.
well, you get to ask a couple of words. I'm kidding.
Well, thank you for being here. Originalism is often cast as sort of a tool of judicial restraint. And I guess my question is basically, and sorry, so I feel like I'm a 1L, so I might be way off on this. But I feel like my feeling is that historically and maybe currently among non-originalists, the preferred tool of judicial restraint is a greater respect for stare decisis. And I guess my question is, why, if there ever were sort of a liberal majority on the Supreme Court in the future, which that's a big if, but if there were, how could the decisions of the current court be overturned or overturned while still respecting stare decisis? How can that be balanced?
Yeah, so a few thoughts. One is, it turns out that going back to originalism is a they, not an it, and an influenza strain that keeps evolving, Justice Barrett has said publicly that justification for originalism is no longer judicial restraint. Like, we're now in like a prime different version of originalism. So just wanted to kind of flag that. As far as, liberal majorities on the Supreme Court and stare decisis, I guess what I would say is, how I describe myself is a constitutional pluralist. Like, I am not just interested in precedent. When I describe myself as like a common law constitutionalist, I'm also interested in historical practice. I am also interested in constitutional structure. And one of Melissa's colleagues, Adam Smaha, has actually done a study showing that when people actually rely on different kinds of sources rather than a single source, that can be more constraining than just relying on a single source like history. As for stare decisis in the future, a few options are on the table. One is just distinguish the cases in the way the Roberts Court has. Be like, well, those were decided on a Tuesday, today is a Wednesday, so no big deal. Some of their distinctions today really do kind of boil down to that. Second is, the stare decisis isn't always a directive not to overrule particular cases. I think there are powerful reasons that you could point to, for example, in the immunity ruling about why that decision in particular should be overruled. Like, it is egregiously reasoned. It is inconsistent with any other number of fundamental concepts its consequences are horrendous. So, stare decisis isn't a never overrule precedent. It's always a debate about which precedents to overrule. And I think the Roberts Court often makes its own case for overruling its own precedents. But also I think that the alternate vision of constitutionalism and constitutional theory isn't just about stare decisis and judicial precedent as such.
All right. It's time for the hat. Okay.
Oh my goodness, look at this hat.
All right. Okay. I'm just going to say this is the kind of technical expertise that the court applied to finding the Dobbs leaker.
Yeah.
So, wow, this is great. Okay, I'm going to pull 10 names out of a hat, and there are these books, okay, that Leah has signed. All right. Leah, I'm going to actually pass the books to you. You can offer them up. Okay, ready? Sarah Pita. Where are you, Sarah Pita? Right there. Come on down. Okay. Elena Zhang. Hang on.
I feel a bit like you're Vanna White.
I know. Or Oprah. Will Warwick. It's 3. Okay, number 4. Hannah Dove.
Thank you.
Okay, just imagine how much fun I am in the classroom. Okay. Chris Obolensky.
Thank you.
Okay, this is number 6. Maximilian Ungert. Okay. I'm going all back there. Ruby Seavey. It's number 8. Jesse Giro. Number 9, Rita Wen. Okay, number 10. Ready? Number 10. Like this. Owen Johnson. Oh! Okay. And because I'm nothing if not a selfless giving educator, I'm going to give you mine.
Well, I also brought an extra, so we can do 2 more.
Oh! It is like Oprah. It's just like Oprah. Okay. All right, ready? Sumaya Siravara. Malcolm Hanchett.
I can get that one too.
Okay, we also have this one here.
13.
Is that a lucky? No, it's perfect.
It's
perfect.
Taylor Swift and my birthday date.
Well, okay. Catherine Guyot. All right.
And that is actually all the books.
That's all the books we have. Thank you so much for coming to the NYU Law Forum. Thank you, Leah Litman.